Again, before assenting to the petition of rights, Charles I had a conference with the judges and put the following question, inter alia, to them: whether, if the king grant the Commons' petition, he doth not thereby exclude himself from committing or restraining a subject for any time or cause whatsoever without showing a cause? The answer of the judges was: every law, after it is made, hath its exposition, and so this petition and answer must have an exposition as the case in the nature thereof shall require to stand with justice, which is to be left to the courts of justice to determine, which cannot particularly be discovered until such case shall happen. And although the petition be granted, there is no fear of conclusion, as is intimated in the question. Afterwards, Charles I issued writs for ship money, directing the sheriffs to assess every landholder and other inhabitant according to their judgment of his means, and to enforce the payment by distress. The greater part yielded, but symptoms of opposition appeared in some places. The judges of assize were directed to inculcate on their circuits the necessary obligation of forwarding the king's service by complying with his writ, but as the measure grew more obnoxious, and strong doubts of its legality came more to prevail, it was thought expedient to publish an extrajudicial opinion of the 12 judges, taken at the king's special command. They gave it as their unanimous opinion that, when the good and safety of the kingdom in general is concerned, and the whole kingdom in danger, his majesty might, by writ under the great seal, command all his subjects at their charge to provide and furnish such number of ships, with men, munitions, and victuals, and for such time as he should think fit, for the defence and safety of the kingdom, and that by law he might compel the doing thereof, in case of refusal or refractoriness, and that he was the sole judge, both of the danger, and when and how the same was to be prevented and avoided. When the case of Hampden came before the 12 judges, sitting as the Exchequer Chamber, however, there was a majority of no more than 7 to 5 in favour of the Crown, the Chief Justice of the King's Bench, Bramston, and the Chief Baron of the Exchequer, Davenport, being among the judges who decided in Hampden's favour. The judgment for the Crown was, of course, afterwards annulled by the Long Parliament. Upon the ancient malpractice of consulting the judges beforehand, it may be interesting to add 3 passages. The first is from Lingard's History of England, 4th edition, volume 5, page 282. Quote, in 1486, Humphrey Stafford, who had fled for sanctuary to the church of Colnham, an obscure village near Abingdon, was taken from the church by force and brought to Worcester to be executed for treason in virtue of an act of attainder previously passed against him, but the abbot of Abingdon arrived on the same day and required that he should be replaced in the sanctuary. This saved his life for the time. He was sent to the Tower, and the judges were consulted by the king, Henry VII, whether Colnham had the privilege of a sanctuary. They replied it was hard and contrary to order that they should give their opinions beforehand on a matter on which they would have to decide judicially. Henry assented with reluctance. The point was argued before the judges, and the claim of sanctuary was rejected. End quote. The second passage is from Lodge's Portraits, 3:1-5. Quote, Sir Walter Raleigh, 1617. After the solemn mockery of a conference held by all the judges, he was, on the 28th October, brought to the King's Bench bar, and required to say why execution of the sentence passed on him 15 years before should not now be awarded. Defended himself with a vigour of argument and beauty of eloquence which astonished all who heard him, and was the next day, under the authority of a special warrant signed by the King, beheaded in Old Palace Yard, Westminster. End quote. The third passage is from Lodge's Illustrations of British History, 3, pages 171-3. It is part of a letter from Sir Thomas Edmonds to the Earl of Shrewsbury. Quote, the judges have of late met at Maidenhead to consider of the crimes of the prisoners, and, as I understand, they make no question of finding them all culpable, save only Sir Walter Raleigh, against whom it is said that the proofs are not so pregnant. Sergeant Harris hath been this day called before the Lords about those business, but I do not yet see any likelihood that he will prove much fault. My Lord Chief Justice and the King's Council are appointed to be here tomorrow to confer with the Lords about the further proceedings against the prisoners, which we conceive will not be long deferred. From the court at Woodstock, in haste, the 11th of September, 1603. End quote. Nor is it to be forgotten that all the Stuart kings claimed the right to legislate by proclamation. In the time of James I, the practice of issuing proclamations interfering with the liberty of the subject, in cases not provided for by Parliament, had grown more usual than under Elizabeth. Coke was sent for to attend some of the council, and was asked whether the king, by his proclamation, might prohibit new buildings about London, and whether he might prohibit the making of starch from wheat. Coke replied that the king could not change any part of the common law, nor create any offence by his proclamation, which was not an offence before, without Parliament, but that it was a matter of great importance, on which he would confer with his brethren. This course was agreed to by the council, and 3 judges, as well as Coke, were appointed to consider the matter. They resolved that the king, by his proclamation, cannot create any offence which was not one before, for then he might alter the law of the land in a high point. For if he may create an offence where none is, upon that ensues fine and imprisonment. It was also resolved that the king hath no prerogative but what the law of the land allows him, but the king, for the prevention of offences, may by proclamation admonish all his subjects that they keep the laws and do not offend them, upon punishment to be inflicted by the law. And the neglect of the proclamation aggravates the offence. Lastly, they resolve that, if an offence be not punishable in the Star Chamber, the prohibition of it by proclamation cannot make it so. The proclamations of the reign of Charles I were far more numerous than those of his father. They imply a prerogative of intermeddling with all matters of trade, prohibiting or putting under restraint the importation of various articles and the growth of others at home, or establishing regulations for manufactures. Prices of certain minor articles were fixed by proclamation, and in one instance this restriction was extended to poultry, butter, and coals. It was declared that the king had incorporated all tradesmen and artificers in London and 3 miles around, so that no person might set up any trade without having served a 7 years' apprenticeship and without admission into the corporation. More than that, it was generally understood to be an ancient prerogative of the Crown to dispense with penal statutes in favour of particular persons, and under certain restrictions. The king might, by a nolle prosequi, stop any criminal prosecution commenced in his courts, though not an action for the recovery of a penalty given to a common informer. He might set at liberty by means of a pardon any person imprisoned, whether upon conviction or by a magistrate's warrant. But Charles II, by his declaration of indulgence, purported to suspend all penal laws in matters ecclesiastical. The House of Commons voted that the king's prerogative in matters ecclesiastical did not extend to repeal Acts of Parliament, and addressed the king to recall his declaration. In his answer to this address, the king lamented that the House should question his ecclesiastical power, a course which had never been taken before. In a second address, the Commons positively denied the right of the king to suspend any law. At length, the king gave way and withdrew his declaration. A collusive action, Godden and Hales, was brought in the reign of James II to test the right of the Crown to dispense with the Test Act. Sir Edward Hales was a Roman Catholic, and the action was brought in the name of his servant to recover the penalty of £500 imposed by the Test Act for accepting the commission of colonel of a regiment without the previous qualification of receiving the sacrament in the Church of England. The king had privately secured the opinion of the bench in his favour before the action was brought, and the prerogative was upheld by 11 judges to 1. Herbert, C.J., laid down that there was no law that might not be dispensed with by the supreme lawgiver, though it was generally agreed among lawyers that the king could not dispense with the common law, nor with any statute prohibiting that which was malum in se, nor with any right or interest of a private person. Soon afterwards, James issued his famous declaration for liberty of conscience, suspending the execution of all penal laws concerning religion, and freely pardoning all offences against them, in as full a manner as if each individual had been named. He declared also his will and pleasure that the oaths of supremacy and allegiance, and the several tests enjoined by statutes of the late reign, should no longer be required of anyone before his admission to offices of trust. It was this declaration, and the prosecution of the bishops for refusing to publish it, that led directly to the Revolution. The most recent case in which the attempt was made, not merely to obtain the opinions of His Majesty's judges beforehand, but actually to establish by statute a system whereby the judges would be ordered and required to give their opinions beforehand behind the back of one of the parties, is afforded by the Rating and Valuation Bill of 1928, a government measure. The proposal which that bill contained, and the protests which it excited in the House of Lords in April 1928, seem to be well worthy of the closest attention. The clause is accordingly set out in full, and is followed by passages from some of the speeches which it provoked. In the form in which the bill left the House of Commons, it contained a certain Clause 4, entitled Decisions of Doubtful Points of Law, which was in the following terms. 4, subsection 1. If, on the representation of the Central Valuation Committee, made after consultation with such associations or bodies as appear to them to be concerned, it is made to appear to the Minister of Health that a substantial question of law has arisen in relation to the valuation of hereditaments, or of any class of hereditaments for the purpose of rating, and that, unless that question is authoritatively determined, want of uniformity or inequality in valuation may result, the Minister may submit the question to the High Court for its opinion thereon, and the High Court, after hearing such parties as it thinks proper, shall give its opinion on the question. Subsection 2. The Central Valuation Committee may appear as parties on the hearing of any such case for the purpose of supporting any contention with respect to the question at issue, and may, if they think fit so to do, contribute such amount as they think proper towards the costs of any persons appearing on the hearing for the purpose of supporting the contrary contention. In the discussion in committee in the House of Lords, speeches were made from which the following passages may be cited. Lord Hanworth, quote, The clause is a specious one. It purports to give an opportunity to the Central Valuation Committee, who are charged with most responsible and difficult duties, to obtain the solution of intricate points which may arise in the course of the rating of certain properties, and this clause would, as it stands, propose to solve problems that may arise and explain certain difficulties. It was pointed out, when this clause was under consideration on the second reading, that it will not effect that purpose without impinging upon the rights of a great number of persons who may be interested. It is all very well to declare that the Minister of Health may, in difficulties which are abundantly explained in the opening part of the clause, submit a question to the High Court for its opinion thereon, and, to the layman, it might be supposed that it is perfectly legitimate for the Minister to obtain an opinion, and that that opinion would be of value. It would be of value, but it might be of great injustice to many others who are not bound by it. The effect of this clause is to enable a minister to submit a question to the High Court and to obtain an opinion. When that opinion is obtained, the minister will be armed with an authoritative declaration which, it might be said, he could apply in all cases. A judgment of the court is binding upon the parties, and it is of authority where the facts are similar and in analogous cases, but it is quite a new thing for the minister to be able to secure an opinion which can afterwards be held in terrorem over others who may have cases somewhat similar. For my part, and I think all lawyers will agree upon this, it is quite irregular and unwise that this power should be given to the ministry, because it might be used, and there is a danger of its being used, in cases where it does not apply, thus preventing those who desire to have their matters decided on their own proper facts from bringing those matters to the attention of the court in the ordinary way. Personally, I am absolutely against the clause altogether." Lord Merivale, quote, "It is a really mischievous clause. I am not concerned with the matters which are here raised. I am not concerned in public administration, and I am not one of any body of judges likely to be resorted to when any question arises under this bill in respect of rating law. I hope I am as disinterested in the matter as any member of your Lordship's House, but I have had acquaintance with the practical working of these things. I have, at any rate, this qualification, that through a long professional life I was often engaged in such matters as here arise, and in various judicial capacities in later times I was concerned with the decision of such questions, and in the personal position of a ratepayer I know how this class of legislation operates. With this knowledge I have the strong conviction that on the whole this clause, in the form in which it is presented, is a mischievous clause. What it would effect, whether it is designed or not, would be to make the judiciary act in an ancillary and advisory capacity to the executive, and confound the working of the judicial system with executive administration. Every student of politics who has considered the matter during the whole of our political history has seen that it is the road to mischief. It was the kind of proposal, the kind of intention, which led to the removal of Lord Coke from his high office, and to his going into opposition against the then government, which of course had an autocratic flavour about it, but which he had honestly, as an Englishman, supported, because, as he said, it established a species of auricular relation between His Majesty's administration and the judges, who had to be impartial in all questions affecting the subject. When this clause is examined, what will be seen is that the department in question, where it is anticipated that grave difficulties may arise, will be able to select a general question of law, a question of general application, to get the sanction of the Minister of Health for proceeding under this clause, and then to take care that, upon a question and with a process of argument which will be regulated by itself, it will anticipate a conflict of authority with the individual by securing, upon arguments which it controls, a decision of a judge which is intended to be authoritative and secure in advance. There is nothing like it in the whole character of our law. I do not know that there is anything like it in the character of the law of any Western state. I have not enough experience of the latest developments of autocratic government to know if elsewhere there is some process by which, when the citizen comes to be in conflict with the executive, he must go to the department with which he is in conflict and elicit from some pigeonhole in which it is placed for reference a decision which they say governs the situation. This is totally contrary to anything that we have known of in the whole history of administration in this country, and for my part I confess that I regard it with great apprehension. I know that it is proposed with the best intention by ministers who desire simplicity of administration and certainty in the application of the law, but this is not the mode by which it is to be got. There is not really any difficulty in securing the opinion of the courts at a minimum of expense upon a case stated with regard to any question which arises in practice. As soon as there is a dispute in litigation, the authorities are in a position, by one or other of the processes provided either in Quarter Sessions practice or in the practice of the High Court, to agree what the facts are, to bring them before a judge, and to argue the question. That is the businesslike, safe, and sensible way in which this class of matter has been dealt with in past times, and the result has been to attach to the judicial decision a degree of confidence which, outside this country, is almost unheard of. It is known that the judiciary have no particular association with the executive, that they are not approached by the executive with a view to their coming to conclusions that the executive desire, that there are not any auricular communications between them, as Lord Coke said, that the thing will have been fairly thought out, and that a decision arrived at in that way falls into the body of the law and guides the opinion of everybody who is concerned.